Friends, we are starting now. Today is a 246th Friday group meeting. The topic is grounds to set aside a sale under SARFAESI. The speaker is our beloved senior advocate and topmost lawyer of this country, V. Mohana ji. Earlier also she addressed our Friday group on same topic almost. That is on 242nd Friday group meeting, that is 10th January 2025. The right to redeem a mortgage under Section 60 of Transfer of Property Act vis-a-vis Section 13 of 8 of SARFAESI. In continuation that she developed some new judgment recently. So she is going to address Mohana. Now you can 45 minutes your speech plus minus you can make out.
Yeah.
15 minutes any questions and all. Further we can go to
sure.
canteen and all.
Well,
Now you can initiate.
Thank you so much. Good evening, everybody. Thanking all of you for being here and helping me educate myself. Thanking Seshu, and as always, he is encouraging and motivating us to learn and be a better person and a better lawyer. And so as I can also share whatever knowledge that I have learned because of his request today. Some of it that I will be discussing today with you or talking about it may be a sort of a little repetitive, because last time when I was talking about 13.8, the right to redeem under the Transfer Property Act and also the SARFAESI Act, we had to touch upon certain provisions of the SARFAESI, like from section 13 and the subsections up to 8 we were touching upon, so that we wanted to tell you what are the steps available under the SARFAESI for a bank or a financial institution. Now, we also went through the rules under which a sale can be set aside. See, right of redemption is one thing. Right to set aside an auction sale is another. Both are rights available to a mortgagor. And under SARFAESI, which is a special enactment, because the extra powers have been given under this enactment to the institutions to sell the property, sell the mortgaged property without having recourse to the court of law, there are certain safeguards as well and also certain methodologies to balance the rights of the institutions as well as the borrowers. There are rights balanced and the provisions are also such. How the courts have interpreted these provisions and at what stage are we now, the courts have interpreted to what level, is what we are today going to see. We had seen section 13. Of course, we have a section 17 and section 18 in the SARFAESI Act, which says whatever measures are taken under section 13 to recover a secured debt, that can be challenged, or any person aggrieved by such a measure can approach the DRT under section 17, or when that doesn't go through in their favor, then the next provision is an appeal to the appellate tribunal under section 18. There are certain conditions of pre-deposit, etc., which has been held to be, when the act was enacted, that provision was also challenged, wherein 75% pre-deposit was held to be bad, and then the discretion has been given to the tribunals to reduce that. Now we are on provisions. I will just initially tell you what are the provisions available for setting aside a sale under this SARFAESI rules 2002. This is called Security Interest Enforcement Rules 2002. Whenever there is a NPA, whenever there is a secured debt, when the debt is not paid, or when the banks realize that it has become an NPA and the dues are not getting cleared, notices are issued under section 13.2. Initially, notice is issued and a reply is called for, and the borrower can raise a reply saying that whether he has a difficulty, or if he is thinking that this is not the amount that he has to pay, there is some calculation error, or there is something of a difficulty, anything, whatever objections are there, he may put it up to the bank, and which is considered by the bank, and then appropriate orders are passed thereafter. If the still amount is due and it is not paid, section 13.4 is resorted to by the banks or the financial institutions, by after which possession of the property is taken symbolically, and section 14 is resorted to at times when they are unable to take possession, they take the help of magistrates through which the possession is taken by the banks or the financial institutions. That procedure all of us know. Now, only to show that there is these are very strict provisions, then we need to know what is the remedy available for a borrower to set aside the sale. Under 13.8, presently the problems and the doubts have arisen in our minds because of a very recent judgment which I referred to towards the end of my lecture last time. In fact, that was the predominant part which I wanted to actually tell all of you about. However, that got a little shunted because of the time constraint that we had. We were talking about a case called Celir LLP, which is the judgment in which the Supreme Court has recently interpreted the 13.8, the provisions of the 13.8, where it says that a redemption right is lost as soon as a notice is issued for sale. As soon as the public notice is issued, the right to redeem is lost. In that judgment, after that there was a continuation, a contempt judgment, after which there has been certain doubts which has come to a few friends of mine. In fact, we used to discuss also whether then what happens to the setting aside of the sale. Once you say that everything is lost, is it lost forever for a borrower? If the 13.8 right is lost, is it to say that the sale which has happened and confirmed, can it be ever set aside or not? That is the issue that comes to our mind, which we will also discuss in this. So I will be taking you through that Celir judgment also, and I will also take you through certain earlier judgments in this regard, whether the provisions of the security interest rules are mandatory, what is the compliance that need to be undertaken, what is the precautions and safeguard that a bank will have to take as a creditor while selling the property in a public auction. Now, we have the rules 5 onwards in security interest rules. After a procedure after issuance of notice is dealt with in Rule 4. Rule 5 says valuation of movable secured assets. These are all certain mandatory provisions under the rules which we all should know. Actually, I must tell all of you will be having at some time or the other a SARFAESI case with you, either for a borrower or for a bank or for an auction purchaser. The moment it comes to you, please verify all these provisions, whether there is in a compliance of all these things, and then your objections, even at the stage of Supreme Court. I know we can't improve upon a case beyond the level at which it has come in the trial court or in the first appellate court also. Nevertheless, if there are certain legal objections which goes to the root of the matter, or is it a fundamental error or a fraud or an irregularity which has happened which can help us get a sale set aside, then probably it's better that to go through this bare act of this SARFAESI along with me to know that what could be the provisions that you can look at. We saw that 13 is the provision under which they get the authority to get the property to sale. Now, so these are the rules under which there are certain safeguards and measures that the banks will have to, or the creditor will have to undertake. One is valuation of a movable secured assets. If there is a factory, or if there is an estate, or if there is a hotel kind of a property, you have to value the movables which are not exactly attached to the earth. Certain movables which are attached to the earth and cannot be detached are also treated as immovables. Why I am saying this? There are cases where we have contested that the movables will have to be separately valued and the immovables will have to be separately valued because there are specific provisions for the same. Rule 5 is valuation of movables. Rule 6 is sale of movable secured assets. There are secured assets which are movables which have to be separately, and the provision is detailed as to how you have to obtain quotations or invite tenders from public or holding a public auction or in a private treaty. The methodology of assessing and putting it up for sale has been very much detailed under rule number 6. I am not going line to line because of the paucity of time. Then rule number 7 is issue of certificate of sale. When there is a movable secured asset sold, then the sale price of each lot will be paid as per the terms of the public notice, and there will be a separate sale certificate for that, and there is a format also given in that. Sale of immovable assets is dealt with in rule number 8. Time and again we keep seeing this rule 8 and rule 9 violation cases reaching the Supreme Court, because most importantly it is the immovables which a borrower will be really worried about most of the times. Majority of the times it's the immovable property sale which is under challenge. So this is rule 8 is something which all of you will have to carefully look at, which is the sale of immovable secured assets. That also there is a methodology by which valuation is taken, an approved valuer is taken, and then who brings out the best valuation of the property considering various aspects, and by obtaining quotations or by inviting tenders from the public, by holding a public auction or by a private treaty. In case of private treaty, it is a private sale in which even the debtor is consulted before that. Then what is the Rule 6, the clause 6 of the Rule 8 says the authorized officer shall show the borrower a notice of 30 days for sale of the secured assets under sub Rule 5, and provided the sale of the asset is being effected by either inviting tenders from the public or by holding a public auction, the secured creditor shall cause public notice in 2 leading newspapers, one in vernacular language having sufficient circulation in the locality, by setting out the terms of sale which shall include, etc. So they say what all will have to be done, what steps will have to be followed. Matthew Varghese says all these rules in the Security Interest Enforcement Rules 2002 are mandatory, and they will have to be complied with for getting a sale actually confirmed and to be upheld by the courts of law. So, and Rule 9 deals with another important aspect, which is time of sale, issuance of sale certificate and delivery of possession also. In fact, Rule 9 contemplates, sometimes what happens, a bank issues an auction notice. For that has to be the initial notice will always have to be 30 days period. The time frame is at least somebody should get a notice of 30 days for a public auction to be held. And earlier provision in 9 was every time there is a separate auction. See, a bank has fixed a date of auction. We have seen in CPC also. There is always under Order 21 there is a sale notice given, and on that day there is an upset price fixed. Upset price is the minimum price below which a person cannot, the auction purchaser cannot bid, and the auction cannot be complete for a price which is below the upset price. So when an upset price is fixed and a sale is notified, even under Order 21, the same principles apply. Here also in Rule 9, it says that when a price is fixed and when there is an auction which is noticed, after the 30 days period, when the auction is taking place, when there are not enough takers or there is not enough price that we are getting, then the sale is postponed. Or even in a situation where there is a stay obtained by the borrower or somebody else for stalling a sale, then it gets postponed. At that point of time, then there is a second sale notice which is effected. For that, earlier Rule 9 said there were 30 days, every time the 30 days notice was contemplated. However, after the amendment in 2016, Rule 9, please note, it is only 15 days after the first sale. Every time after the second, third, fourth, whenever the sale notice takes place for the same property, every time there has to be a 15 days notice, and it is not 30. So as per the Rule 9, that amendment has also been effected, that there should be a 15-day notice. And also there is a proviso which says that you cannot sell the property, you cannot give the sale certificate for a price lesser than the reserve price which has been fixed. That is also a rule. But if you are doing that, you will have to get the concurrence of the debtor whose property is being sold. These are the provisions under the SARFAESI, apart from many others. I am just quoting only these because these are the provisions which are normally used to come to the court by these borrowers and to set aside the sale whenever there is a sale which has happened, overruling or overlooking the provisions which are mandatory. In this regard, I would say that but I must say there are certain things that the Supreme Court has held also over a period of time. One is that whenever there is a sale which has happened under SARFAESI, if anybody is aggrieved, there is a section 17. So therefore, everybody, there is a statutory mechanism under which that your challenge can be taken up. So therefore, because under 17, if there is a pre-deposit, many people started going to the High Court directly. When the SARFAESI Act came, after which many people, after these sales, they started approaching the High Courts under 226. So when this started coming, there were one of the very important judgments in this regard is the Supreme Court in United Bank of India versus Satyavati Tandon is one of the landmark judgments in this 2010 8 SCC 110 Satyavati Tandon, in which the Supreme Court said that High Courts cannot entertain writ petitions under Article 226 in matters of SARFAESI. If at all any person is aggrieved, they should approach the tribunal which is provided in the statute itself under section 17. So this is a judgment in which the court has traced the entirety of the legislation of SARFAESI. In fact, you can go through this judgment, and the law is fully traced about, and it also says that the provisions also give, even section 17 is not only available for a borrower, it is also available to anybody who is aggrieved by an action or an inaction. So therefore it covers everybody. When there is such a statutory mechanism, borrowers or anybody cannot approach the High Court. This is what it says. It is true that the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion, but there can be no reason why the High Court should entertain a petition filed under 226 of the Constitution and pass interim orders ignoring the fact that the petitioner can avail effective alternative remedy by filing application, appeal, revision, etc., and that the particular legislation contains a detailed mechanism for redressal of his grievance. So therefore, Satyavati Tandon, please note that whenever a client comes to you, they may have some problems depositing or anything, but then if you only go to the writ court, it is not going to help us in the long run, because it has to be as per the alternative remedy which is provided under the enactment. For a shortcut, it may be giving you a short, but then right now even that is not happening. It was initially happening, but after that the writs were always dismissed and we were in a worse off position thereafter. In fact, this position is now confirmed even in the latest judgment of Selir, which I will be coming to in a short while. Even the Supreme Court in the matter of 13.8 redemption matter, also the Selir judgment, which is now the settled law on the redemption, and as well as this also says as a major position is that High Court cannot entertain, because even in Selir the parties, after approaching the DRT, dropped it midway and approached the High Court under 226. So therefore it is now settled that please don't go to High Courts under 226. Then the next one on this will be actually an auction. These are rules which I pointed out under rule 8, 9, 5, 6, 7, 8, all of them. These rules are mandatory in nature and these rules are statutory in nature. So therefore these statutory rights can be waived by a borrower. These are actually meant to help the borrowers, for them to get out of the situation or to challenge anything which has happened, which is beyond the legal parameters. However, by conduct, by express verbally or by in writing or by their own conduct, they can waive their rights of this complying with these rules. So whether that is one judgment which has been discussed in RC Polymers, which is 2022 2 SEC 221. Sorry, yes. 2022 2 SEC, yeah, I've given it, yes. RC Polymers, in which what had happened was that in RC, the people, the auction purchaser came to the Supreme Court because the auction was set aside on the application filed by the borrower. What had happened in RC Polymers was that the borrower, I had mentioned in the beginning, there is a provision called 13.3 in which a borrower, after a notice under 13.2 is issued, you get a right to make a representation as a borrower. I am saying this because today since we are only talking about the right to get the sale set aside, so I am assuming that we are talking in the perspective of a borrower today. Of course, you will all be appearing some days for an auction purchaser, some days for a bank also. But today, only looking at that perspective, I am saying the borrower had made his objections under the Act, and 13.3a is a provision under this Act itself which says that whenever there is such a representation made, they are supposed to deal with it and make a reply. If on, this is the provision 13.3 capital A, if on receipt of a notice under 13.2 the borrower makes any representation or raises any objection, the secured creditor shall consider such a representation or objection, and if the secured creditor comes to the conclusion that such a representation or objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such a representation or objection the reasons for non-acceptance of the representation or objection to the borrower, provided the reasons so communicated or the likely action of the secured creditor at the stage of communication of reasons shall not confer any right upon the borrower to prefer an application to the DRT under section 17 of the Code of Procedure, etc. That is, there is a right given to you Under 13.2, when there is a notice given to you that you are supposed to pay X amount to the bank, we are now declaring you NP and you have to now be ready, please pay it in 15 days, whatever. You are writing a representation opposing that, raising your objection. They are bound to reply you under 13.3a, that is also mandatory. A bank is bound to reply you, the creditor, and then deal with your representation and then either say you are correct or you are not, or you say partially correct or whatever, they have to reply you. So in RC Polymer, but then the proviso says this will not give you a right to go under section 17. This will not be deemed as a justiciable right for which you can separately go under section 17. In 17, when you go for other angles, other points, you can add this as a ground. I hope you all understand. When there is a sale which you are challenging, you can take 13.3a as an additional ground. However, you cannot go under section 17 as a separate point as taking 13.3a as an objection. So in this case, what had happened, after 13.3a violation also, the sale had happened in RC Polymers, and the main objection was mainly that 13.3a was not considered. There was no representation, consideration, rejection, and the secured creditor proceeded to hold the sale, in which the violation is that the movables and immovables were not separately valued and therefore the sale itself is invalid. 8 and 9, the validity under section 6 and 8 and 9, they were all challenged. The High Court had actually allowed the petition, and there was an appeal by the auction purchaser, who was a successful person in whose behalf the sale certificate, on whose name the sale certificate had also been effected. So there they considered this, the non-consideration of a borrower representation. There the Supreme Court said, if you make a representation and continue to, by your own conduct, waive that you had such a right, and then make the next step of arguing with them, or bargaining in the OTS, or even going to the next level of saying that the property, this is amount that I admit, or anything to that step, that level, then it means you have waived your own right, and then you are stopped from challenging this on this ground. That was one. Secondly, on the issue of machinery valuation also, it was held they were properly valued, and therefore there is no question, because in that case the machineries were attached to the earth and they were valued in toto, along compositely with the immobile properties, and therefore that was a factory running, and therefore the court said, Supreme Court said, it couldn't have been valued separately, and there was a validity, the sale was upheld, and auction purchaser's appeal was allowed by the Supreme Court. That is ARCE Polymers. In this very line also you will find this one, the other judgment, there is another one judgment is Vasu Shetty. In fact, in Vasu Shetty, I'll just tell you the citation. One of the very important judgments is Vasu Shetty. Of course, I have mentioned Vasu Shetty in my last lecture when I am talking about the mandatory provisions of the SARFAESI. This is 2014 5 SEC 660. This says about the mandatory nature of rules 8 and 9. In this case, though it says in Vasu Shetty, the argument was the borrower had approached the creditor saying that I am willing to pay X amount under OTS, so therefore I can pay this much. So that conversation was happening between the bank and the borrower. However, while this was happening and when the deadline was not met by the borrower, there was a sale which has happened at the behest of the creditor, and that was challenged in this by the borrower. They defaulted in payment. Then therefore the argument was that since there was not enough notice as per rule 8 and 9, so therefore the contention of the auction purchaser was that the appellants, that the borrowers never actually they did not abide by the OTS, and thereby they gave up their right because they were willing to forego their rights, and then they came for an OTS. I don't have to abide by the rules is what the argument. But the Supreme Court said like this, that the borrowers can always waive their rights because they are all, the rules, because they are all for the benefit of the borrowers. But it is a question of fact in each case, and the courts will have to apply their mind and go into it to see whether the borrowers are actually by their own physical or an implied conduct given up their right to challenge the validity of a sale. And the violations in this case were expressly in Vasu Shetty, I must say, the violations were actually admitted by the secured creditor, but the argument was that no, because you never questioned it, you never wanted to you just wanted to pay an OTS amount which you never abide by. So therefore we thought that you will not be having any objection about the sale, so therefore you can't challenge it. You are stopped, was the argument. However, in this case the court said by conduct examination has to be done, and if case to case basis they have, every court will have to see whether a mandatory condition has been waived by the borrower as such. So finally what happened was, in this case the sale was set aside, and the court said the borrower, in fact, they gave one step extra. They said the borrower is given one more opportunity of some 1 month period that for the money to be repaid to the bank and then take the property in their possession. Otherwise the property will be put to a fresh auction, not the very same sale. Anyway, the auction sale was set aside, giving a fresh lease of life to the borrower. So there, in this case, the reliance was made on 3 judgments. One is Rajiv Subramanian, another one is Matthew, another one is Iqbal. Out of which Rajiv Subramanian and Matthew will be considered in Rajiv also. I can take you to that Rajiv Subramanian, which is the very, very important judgment, 2014 5 SCC 651. A very good judgment by Justice Nijjar. This is also regarding violation of rules 8 and 9. Though issue of maintainability was there, but that was given up. Though it was, in fact, in Rajiv Subramaniam was also, the parties went to the High Court. So initially there was an argument about whether you could have approached the High Court under 226, but since there were many other points, that maintainability issue was given up, and the arguments were predominantly on the violation of rule 8 and 9. In this there are certain paragraphs. They rely upon Matthew Varghese, and then they say like this. They're very beautifully written. In fact, Matthew is a very good judgment. Matthew versus Amrita Kumar is a very settled law in this now, which holds the feel even today. Is that citation will be 2014 5 SCC 610, which is mentioned in para 12 of this judgment of Rajiv Subramaniam. It says that a borrower should be put on notice, and what it says is that the sale, whenever, see, this is what it is. Sorry, yeah. I'll just read only 4 lines for you. The court in Matthew Varghese, para 13 of this Rajiv Subramaniam, further observed, the provision 13.8 is specifically that protection of borrowers in as much as ownership of the secured asset is a constitutional right, etc. Therefore, the secured creditor as a trustee cannot deal with the property in the same manner that it likes, and such an asset can be disposed of only in the manner prescribed under the SARFAESI Act. Therefore, the creditor should ensure that the borrower was clearly put on notice of the date and time by which either the sale or transfer will be effected in order to provide the required opportunity to the borrower to take all possible steps for retrieving his property. Such a notice is also necessary to ensure that the process of sale will ensure that the secured assets will be sold to provide maximum benefit to the borrowers. The notice is also necessary to ensure that the secured creditor or anyone on its behalf is not allowed to exploit the situation by virtue of proceedings initiated under the SARFAESI Act. So this is the crux. A borrower, when they come, that's what they notice also. They are in dire straits, and therefore, you can't, though these provisions are strict, so therefore it is all the more necessary that there should be a strict compliance of these rules, and therefore whenever there is a violation, it leads to the setting aside or the sale. So, but in this case, in Rajiv Subramaniam, they said the sale was held to be null and void because the amount was very little and the property was sold for a song, and the sale was held to be null and void. The amount was to be deposited and the property was to be returned to the borrower. This, in fact, they rely upon a series of judgment, one of which is very old. You can rely upon it later on. There is a judgment called Valji Kimji, which is one of the old judgments, which is not actually one of the SARFAESI, but it is a money suit in which the decree was given. And sorry, it's a company liquidator sale, 2008 9 SCC 299, which is which also is about the fraudulent sales, whether there is a fraud or anything. Yeah. Then they talk about this. These are certain judgments in which the validity of rules 8 and 9 have been considered. So I am trying to say that all these rules become very important and they are mandatory. when this was happening, only this Selir case also come. So we have time?
No, we have time. Sufficient.
So yes. So now, when these judgments were there only, at some point I would like to refer to, there are, we had noted Ramkishan, etc. there, they say, and recently what is settled, which has been earlier also settled in Selir, is that, assuming there is a 13.8 also, there is a right to redeem is lost. But when you have a right to challenge the sale under any other provisions like a Rule 9 or so, then that will have to be agitated as along with your other objections, like under when you are first time approaching the DRT for the same purpose. In Selir, what had happened was the property was brought to sale. It was about more than 100 crore of liability. 13.2 was issued, 123 crore as on 30th April 23 was payable. Borrower challenged the 13.2 notice, and 9 times notice was given. Sale did not mature, and the 9th sale was later on. This sale was confirmed in favor of an auction purchaser. Then borrower filed when the auction purchasers when the DRT securitization application was pending, in which sale has taken place and the sale was to be confirmed. In that itself, an application was filed by the borrower for, suddenly he gave up the challenge to Rule 9, etc. A challenge under Rule 9, and then he says that I want to redeem the mortgage. So both the applications were heard by the DRT and the judgment was reserved. At that point of time, the borrower approached the High Court with an application, a writ petition, that I want to redeem the mortgage. So therefore, let me deposit the money. The bank also agreed, and therefore the sale was set aside, and then the High Court allowed the writ petition. Auction purchaser came to the Supreme Court. Then here, while arguing also, the bank accepted, and then it was noticed that the bank has accepted. Subsequently, the borrower, the Supreme Court allowed the auction purchaser's appeal, saying that under 13.8, what is happening is that, first of all, the Supreme Court said a writ petition under 226 ought not to have been entertained, because already your application under DRT you had approached and then you gave it up. And secondly, when there is an alternative remedy, you shouldn't have approached 226. Time and again we are there, the Satyavati Tandon, etc. are there, so you couldn't have gone to the writ court. Secondly, it said auction purchaser sale cannot be set aside unless there are serious errors, and that also you have not challenged it. So therefore, since you have come for a redemption, which right is lost under section 13.8 once the sale notice is published, you cannot now come, it's a very belated stage. So even assuming you are paying the entirety of the money and something extra can't be set aside. So therefore, the auction purchaser's appeal was allowed, and the Supreme Court directions were to revoke the sale deed, etc. There was no express order granting possession. In the meantime, after the High Court judgment, what had happened was, possession was given to the borrower, and the sale was reversed, and the bank had executed a document in favor of the borrower. And the borrower had actually executed a document and dealt with the property with a third party stranger. And the third party was in possession of the property. So after the Supreme Court allowed the auction purchaser's appeal, what happened was, the borrower refused to respond to the bank's letters saying that giving back the possession, and also the assignee from the borrower also said, I am not bound by this judgment, I am not a party, I am a bona fide purchaser, so therefore I cannot be giving it, so I am not bound by it. He filed a separate civil suit also and got a stay order. The borrower went to the same DRT and then said Rule 9 is violated. So earlier what is decided by the Supreme Court is actually 13.8. So therefore Rule 9 violation I can now agitate. So therefore the sale will have to be set aside, because there is no 15 days notice in the auction sale is what they argued. So that when that was pending, the DRT dismissed it, saying that, taking a very strong view that after the Supreme Court judgment, how can you approach the DRT under this application, because all your avenues, everything has been exhausted and you have given up your right to challenge the validity of the sale under 9. They went to DR80, and DR80 granted an order of status quo. That was there, and the auction purchaser, unable to go anywhere, he came to the Supreme Court in a contempt application, saying that your judgment in letter and spirit has not been complied, because your judgment extensively deals with my right and then says there is no question of any revocation. Now where is the question? I am not able to get the property. There is one suit there in which there is an order 7, rule 11, these people file, and that is also dismissed. So that suit is there. Here there is a DR80 status quo. Where does one go? Because after the judgment, then in the contempt, it is a very elaborate judgment in which the Supreme Court deals with the contempt aspect. So the argument by the borrower was, it's a very something which we all should, I feel that we should all learn as to how to take a case. In fact, how much a case can be looked into in all corners before agitating one right, and then we have to see whether that right could have been agitated again here and in what level a case can be taken up in arguments. One is that earlier the argument of the borrower is, earlier Supreme Court has only decided 13(8), and so the validity of auction is not decided, and the court has only directed sale certificate and not a possession. The court has not directed physical possession. So therefore, for that purpose, section 14 will have to be approached. So therefore, there is no question of any contempt petition lying here in this court, is what they argued. And then they say orders passed in civil court or in the DRAT cannot be agitated in the contempt application. So therefore, this court cannot deal with this in the contempt jurisdiction. That's another argument. And then they argued that there is no 30-day notice or a 15-day notice in a subsequent sale, and validity of auction was never decided by this court. The subsequent transferee also argued in the Supreme Court. They say, I am a bona fide purchaser, not a party. For a question from the court whether they were aware of the case which was pending, they said, yes, we were aware of the case. Only after that we purchased this. However, they say, I am not a party, so I am a bona fide purchaser. And then, so therefore, lis pendens will not apply, since there was no stay order when it was given to me. And due to their undertaking, they said the Supreme Court, when they took a strong view, now they withdrawn the civil suit also. So therefore, they are saying, we have invested so much money in this property, now there is no way the validity can be set aside. No, I mean the validity can be gone into, because I have now got it from the borrower. Now the findings begin from para 124 of this judgment. It's a very, very important judgments. All of you read it when you get the time, because this judgment doesn't stop with only the validity, in fact the contempt angle. It also deals with 2-3 other important angles. One, it says the DRT has wide powers. That is discussed about section 17, section 18, the other powers under the act, and then the rules, etc. How the DRT has wide powers, and the borrower has opted, despite the DRT, he could have very well gone there, agitated this angle as well as the Rule 9 angle. Since he didn't do it, he has opted to file a writ petition, and therefore the writ court even otherwise could not have gone into it. Secondly, having agitated all the points in the writ court, even in the review, they also filed a review in the Supreme Court which was dismissed. So therefore, these points can never be agitated. They said since he never agitated it, they gave it up, in fact, openly saying that this is the only point we want to agitate. So therefore, on that reason, the court said that you cannot. You have abandoned your plea of validity. The plea has been waived by your own express conduct, and the sale is hit by lis pendens. They have also dealt with lis pendens to a large extent. Please go through it. That will be a settled, I mean, up-to-date law has been traced, and also the judgments about whether to implead a subsequent transferee or not, those judgments, Thomson Press, etc. have also been dealt with. And then they say the assignment is void. Parties should have abided by the express directions given by the Supreme Court. You can't expect the Supreme Court to deal with every single line, because the consequential action of setting aside a sale and also the setting aside the sale certificate, or even affirming the sale certificate, will be the consequences should follow. That means the possession will have to be given. That is why we allowed the auction purchasers appeal. Now to come and say possession order is not there amounts to contemptuous act, is what it was held. Finally, the act was held to be contempt, and then they say we are giving you one last opportunity without holding you on contempt. The act is contemptuous, but then if you can do the needful within a month's period, probably we will look at it. We will not pass any order in contempt. This is a judgment which also deals with a portion, when can a sale be set aside. Having said all these things, the door is not closed for a sale to be set aside. Is that in this judgment they refer to various case law, and then Valji Kimji also, Ramkishan judgment, where they say the best interest of the borrower has to be kept in mind. If the price is inadequate, or if the sale is fraudulent, or due to coercion, or due to misrepresentation, or a collusion between the bank and the auction purchasers, etc. These are broad headings which the Supreme Court says in this judgment that a sale can be set aside. However, in that case, these were not raised in the first instance when they came to the High Court and the Supreme Court. They gave up their right. So therefore there was no challenge to these validities, what the Supreme Court says. So therefore it is not an ultimatum to say that you can't challenge the sale at all. You can challenge the sale. There are 5 large grounds given. And also the Supreme Court beautifully traces how an auction purchaser's right also is balanced. They say the 1967 Supreme Court of Janakraj versus Gurdyal Singh, where they say even assuming when a sale is set aside, the right of an auction purchaser is always safeguarded. Under what circumstances? For a bona fide purchaser. So all those things are traced, and then it is finally directions have been given. So this judgment is now settles all these headings. In fact, by justum generis, we can say like, you are saying that the property has not been valued properly. In a case where you are arguing that, please ensure that you get some documents or something contemporaneous to the sale to show that the property valuation is incorrect or anything like that, so that your case is taken on merits and taken seriously. Otherwise, when a sale is confirmed and it comes to this court, there is a negative issue of when there is a confirmation of sale. So therefore they don't look at it in a serious manner unless you have something very material to say that. So in fact, when we are deal with DRT or the sales or any appeals or in the Supreme Court also, these provisions will have to be kept in mind, is what I would like to say. And I think probably we exhausted about 40 the limit of that the Seshu has afforded me. I think by now, I think we can say that borrower has, though limited, rights to get the sale set aside when there is a sale. And there are these judgments will help you, take you through this, and whenever you come across, when you apply your mind and read these judgments, you will probably get an idea as to under which heading your case will fall and bring it under, coupled with the facts of those cases, and even whether there is an implied conduct or express, everything you can look into and advise your clients accordingly also. All the best. Thank you very much for this opportunity. Yeah, I hope I made this little clear. Thank you.
Thank you very much, Mohana ji. Very nice. Within 48 hours notice, she delivered this lecture. Supposed to be Nagamutu, he had some urgent matter in Jharkhand. So he told, just excuse him, he's already in jail, something like that. Great, Mohana. You really, one of the rarest, such a tough topic and subject also. Let us give a standing ovation to Mohana ji also.
Thank you. Thank you so much. My juniors Bhavya and Shri Priya, as usual, they always help me and they have helped me prepare this also.
Now I request Geetanjali Sharma will give a vote of thanks.
Good afternoon, everyone. Moment of immense delight for me to be offering thanks to the Mohana ma'am, senior advocate, for delivering this academically and intellectually stimulating lecture on the topic of grounds to set aside sale under the SARFAESI Act. Ma'am very diligently took us through sections like 17, 18, 13.3a, or violations of Rule 8 and 9. Ma'am also discussed the evolution of the law through cases like Matthew Verghese, Satyavati Tandon, RC Polymers, Vasu Shetty, or Rajiv Subramaniam. Ma'am, subjects like SARFAESI, etc., rather drab subjects, and we thank you for delivering the lecture in a very concise and intelligible way. Thank you all for making yourselves present in large numbers. It is because of your presence that we are motivated at the Friday group to deliver more and better. Thank you to the man who's at the helm of affairs of the Friday group, G.Seshagiri Rao sir, for being perseverant to be delivering these, to be arranging these lectures week after week every Friday. Thank you so much. Thank you, everyone.
Only signature, next message.
Achha, sorry.
Only
signature.
Yeah. No, it is
Signature.
autograph. Instead of signature, autograph.